Domestic violence is an all too common problem. Often victims who have experienced this kind of abuse are afraid to seek help or are unsure of the resources that are available to keep them safe. An order of protection is a special type of court order that protects a person who has experienced domestic abuse, sexual assault, or stalking. There are no costs or fees involved in asking a court to issue an order of protection. A victim of abuse can ask the civil court to issue an order of protection, regardless of whether there are criminal charges against the abuser. Valid orders of protection issued by a New Mexico court can be enforced throughout the United States. An abuser who violates an order of protection can be fined, charged with a crime, or held in contempt of court. Asking the court for help can seem intimidating, but there are resources available to you, and the court has designed the order of protection process so that individuals can seek an order on their own or with the help of an attorney. Most people don't have a lot of experience with the court system, and the process can seem overwhelming. Over the next few minutes, you will learn how to petition for and respond to an order of protection. We will explain how the process works, and once you understand the steps, we hope it won't seem so intimidating. In New Mexico, orders of protection are issued through special domestic violence proceedings, presided over by a domestic violence commissioner or a district court judge. These proceedings get started when a victim of domestic abuse, sexual assault, or stalking asks the court to issue an order of protection. The victim must file special paperwork called a petition. Individuals filing for an order of protection are referred to as petitioners. Those who are accused of abuse are referred to as respondents. A petitioner can seek an order of protection against a respondent, whether or not they live together. Valid orders of protection issued by New Mexico district courts are enforceable in all 50 states, tribal and federal lands, military installations, and U.S. territories.
It tells the abuser to immediately stop the abuse against both the victim and their child or children.
It's really one of those mechanisms that can provide immediate protection for victims and get them out of violent situations. And so I think it's incredibly important in this community and in the society these days.
While the court issues orders of protection, it's important to understand that the process of obtaining an order is petitioner-driven. It's up to the person seeking the order to obtain all of the appropriate forms, fill them out properly, go to the court hearings, and provide the court with evidence of abuse. In most cases, petitioners and respondents are able to represent themselves and do not need attorneys. The first step of the process is to obtain the forms needed to request an order of protection. Forms can be obtained from victim service agencies, law enforcement, attorneys, prosecutors, the district court, and online. In many cases, all of the necessary forms are made available as a packet. The person seeking the order of protection is responsible for filling out the appropriate forms and taking them to the court clerk for filing. The most important part of the petition is to include an accurate and complete description of the abuse. This is a key piece of information the court will use in deciding whether to issue the order. In addition to the petition itself, petitioners will also need to fill out the Service of Process form. This form provides the court with information about where to find the respondent so that he or she can be notified of the order and the hearing. Petitioners will need to provide detailed information to ensure that the respondent can be quickly found and served. An order of protection does not go into effect until it is served on the respondent. If the petitioner has questions when filling out any of these forms, victim advocates and district court clerks can provide information about the process. Only attorneys can provide you with legal advice. Court clerks cannot answer legal questions or give legal advice. Petitioners need to fill out forms completely and accurately and submit them to the district court. Petitioners must sign their forms in front of a notary public. Court clerks can provide notary service free of charge. Forms must be notarized, so petitioners should bring identification with them. Petitioners will not have to pay any filing or service fees when filing their petitions with the court. Sometimes the person seeking an order has changed addresses or phone numbers and doesn't want the respondent to have their new contact information. Petitioners who want to keep this information confidential need to fill out the appropriate paperwork. This form is usually included in the petitioner's packet. When a petition for an order of protection is filed with the court, a judge or special commissioner will review the petition as soon as possible to decide whether the court should issue what is called a temporary order. That means the judge or special commissioner will read the petition and decide whether the information provided justifies the need for a temporary order of protection. If the court issues a temporary order, the petitioner must follow the court's instructions to have the order filed and served. The temporary order is not enforceable until the respondent has been personally served. A temporary order is usually valid for 10 days. The court will hold a hearing within 10 days to hear both sides of the story and decide whether to issue a longer-term order of protection. Just because a court issues a temporary order does not mean the court will issue a longer-term order of protection. If the court does not issue a temporary order of protection, there will be a formal court hearing within 72 hours to review evidence and decide whether to issue a longer-term order.
When you file for an order of protection, you become the petitioner in this case. It is your responsibility to follow through on kind of every stage of the process.
Once the court issues a temporary order of protection, the person named as the respondent will be served the temporary order containing a notice of hearing. It is important for the respondent to comply with the terms of the court order and to appear at the hearing. If the respondent thinks that the court should not have issued the temporary order, then the respondent will have an opportunity to explain why at the hearing. The respondent will also have a chance to present evidence and witnesses and to dispute the evidence presented by the petitioner. In most cases, respondents represent themselves. They may choose, however, to hire an attorney. In some cases, the respondent may be the victim of abuse. Respondents who think they are entitled to their own order of protection should file a counter petition. The judge or commissioner will consider both petitions at the same hearing and rule on each.
There's always two sides of the story. We're the court, and we are going to listen to both sides of the story and then try to determine where the truth is in terms of what has been presented.
In our legal system, the courts are required to be impartial. Judges, clerks, and other court personnel cannot offer legal advice to petitioners or respondents. It is the court's responsibility to determine whether or not an order of protection should be issued, based on the evidence presented to the court. The next step in the process is a hearing, so the court can determine whether a longer-term order of protection should be issued, and if issued, what specific protections the order provides. A hearing is an official court proceeding. It is important that all parties show up on time and are prepared for the hearing, which includes being properly dressed. For the court hearing, both parties and their witnesses will have to be at the same place at the same time. If at any time before, during, or after the hearing, either party feels threatened or unsafe, they should tell a court security officer. The purpose of the hearing is to give the petitioner a chance to present evidence supporting their claims of abuse, so that the court can decide whether to issue an order of protection. The hearing also gives the respondent a chance to dispute the petitioner's claims. A respondent can also present evidence to the judge or special commissioner in their own words. Both parties should bring to court any witnesses and documents that support or refute claims of abuse listed in the petition. Documents might include police and medical reports, telephone records, photos, and text or voice messages. Parties should also bring all documents concerning child custody, distribution of property, interim support, proof of income, medical bills, and other damages. The court may review these documents and listen to witness testimony. Some evidence may not be considered because the court has specific rules about the types of evidence it can allow. Do not bring children unless you have received special permission from the judge or commissioner to do so. The court will issue an order of protection if it finds that an act of domestic abuse has occurred. The person protected by the order is called the protected party, and the person against whom the order is issued is called the restrained party. New Mexico law does not specify the length of an order of protection, but there will be an expiration date set by the court. In all cases, the order restricts contact between the protected and restrained parties. In addition to restricting contact and prohibiting harassment, the court may impose other conditions, such as awarding temporary use of the residence to one party or requiring the restrained party to attend counseling. Since every case is different, the law gives the court flexibility in creating a set of conditions that fits the circumstances of each case. In some cases, the court may also temporarily order or modify child custody and support. These child support and custody provisions are only in effect for up to 6 months, unless the court extends these conditions at a later hearing. Ongoing child custody and custody matters must be resolved through family court.
They got to come in prepared to tell their story, even if it means they have supporting witnesses to testify on their behalf.
It's also very important that once you file for an order of protection that you take it very seriously, because I can tell you that everyone else involved is.
It's a process that they should expect that both sides will be treated fairly. The information is going to be very important. How they present the information to the court will make the difference in terms of whether or not an order of protection is issued or not.
A valid order of protection sets specific conditions that the restrained party must follow. This person must comply with all the conditions listed in the order. If a restrained party does not comply, he or she can be brought back to court and in some cases arrested and placed in jail. A judge will hear each case and decide if a violation has occurred, and if so, what kind of punishment should be imposed. Protected parties should keep a copy of their order with them at all times. That way, if the restrained party violates the order, the protected party can show the order to the police. Although the police do not need to see a paper copy of the order to enforce it, a physical copy of the order makes the job of the police easier and avoids confusion about the order. Violations of orders of protection are considered crimes and should be reported to law enforcement and the court that issued the order. In emergency situations, parties should call 911. To notify the court, protected parties must file paperwork alleging a violation of the order. The court will hold a hearing to determine whether or not a violation has occurred. If the court finds that the restrained party violated the order, then the court can impose sanctions, including fines or jail time. It is important to remember that once an order of protection is issued, it is an official court order. Only the court has a power to change the terms of the order. If the parties want the order changed or dismissed before it expires, they must go to court and ask the court to change or dismiss the order. New Mexico orders of protection have an expiration date. It is important to pay attention to that date. If the protected party wants the order to last longer than the date on the face of the order, then he or she must go to court and ask the court to extend the order. It is the protected party's responsibility to file for an extension before the order expires, as the court cannot extend an order after it expires. If an order of protection expires, the petitioner would be required to start the process from the beginning and provide evidence of a new incident of abuse. Orders of protection are an important tool offered by New Mexico law to protect victims of domestic violence, sexual assault, and stalking. Both petitioners and respondents must meet deadlines, attend hearings, and comply with all of the court's orders. The process is free of charge, but not free of responsibility.